Okay, the WTO as an organization was started functioning the 1st of January 1995. Now that's very, very late, yeah, for an major international organization to see the day of light. Because most of the international organizations that you will be familiar with are much older than that. Some of them have been established in the immediate post-war period, others in the years after, but 1995 is very late. So the question that arises in this context, why is that? Why were they so late in establishing an international organization on trade? Now, the simple answer is that there was indeed, and has all the time been since the late 40s, there has been a de facto organization on trade. The GATT, yeah? The GATT 1947, that itself was an agreement. It was an agreement, a multilateral agreement on tariff reduction. Nothing more, nothing less. It did not set up any institutions. It did not set up any infrastructure, any secretariat. It was a pure agreement on a multilateral agreement on the reduction of tariffs. Now, and it was supposed to be the first real substantive outcome, substantive product, substantive result of the International Trade Organization. The what? Yes, the International Trade Organization. Never heard of. Well, I can't blame you because that organization, whereas it was the charter of that organization was agreed on and signed in Havana in 1948, that organization never came into being because the United States, who had been the big promoter of that organization in the immediate after-war years, the United States turned isolationist and thought that they had no need anymore of such an organization. And Congress never ratified the ITO charter. In those days, it was definitely the case that an international organization on trade without the United States was not worth having, so that organization never took off. But that created a huge problem because during the war, very last end of the war, they had set up the Bretton Woods organizations. The Bretton Woods Temple with the IMF, the World Bank, and it was always in the idea of people that there would be a third pillar to that temple, which was not agreed on in Bretton Woods in 1944, but it was clear that there would be such a pillar. An organization dealing with international trade. And they started then negotiating about that organization in London in 1946. These negotiations that went to Geneva in 1947, where a provisional agreement on the GATT was reached before the organization actually existed. And then in Havana, the charter of the ITO was signed, but never took off. So there was a stillbirth, as you want. What did the GATT do? That one agreement that the negotiators had been able to agree on, the GATT actually then became the de facto international organization to fill that place, the Bretton Woods Temple, that pillar that was missing because the ITO never took off. The GATT took that place, but obviously in a very pragmatic way, because this was not an organization with bodies, and so it only very gradually and in a very pragmatic way got many of the features of an international organization. But it was never, formally speaking, international organization. It was a de facto organization. Has the GATT been a success or a failure? It has been a success in terms of tariff reduction. Because, and this is often said, average customs duties imposed by developed countries, but in 1948, the world was almost solely populated by developed countries. The rest was colonized. Yeah. In 1948, customs duties on industrial products were, on average, 44%. Yes, that's shocking. That's very high. But that was 44%. At the end of the GATT years, 1995, average customs duties were at 4%. Now, I don't know how you define success in life, but if you go from 44 of something bad to 4% sort of bad, I would call that a success. And yes, the GATT was a success in that way. The GATT was not a success in virtually everything else that dealt with trade. It was not a success with regard to quantitative restrictions, with regard to trade remedies, with regard to you name it. Whole sectors were de facto excluded because the GATT itself did not exclude them. But think about agricultural products, think about textiles, all sorts of rules, also measures were in force that were GATT inconsistent, but nobody touched them. That was the practice. So the GATT was not successful in many other ways. In addition, by the 80s, early 80s, certainly early 80s already, trade in services had become much more important. Modify that statement, had been very important to many developed countries. Not necessarily already more important than trade in goods, that comes later, but trade in services was more and more important to their economic development. And the GATT did not cover trade in services. So, then we start with the URGA round. The URGA round with, as we know now, but we didn't know that when it started, is the first round, was the last round under the GATT, the last GATT round of negotiations. It started in Punta del Este, Uruguay, beautiful resort. Trade diplomats really know how to treat themselves well. Started around in Punta del Este. In the Punta del Este Declaration, there was no mentioning yet of the establishment of a new organization on trade. There wasn't. It was all about making the GATT rules more performant, having a better dispute settlement system, having some rules on trade in services. Yeah. But no talk about establishing an international organization on trade. That only came about in 1990. 1990, the first ideas were thrown on the table. I'll save you the various steps of this. What eventually mattered was a proposal made by the European Union, which was called European Communities at the time, Canada and Mexico. Those three proposed the setting up, the creation of a multilateral trade organization. Multilateral trade organization. And they tried to convince the rest of the GATT contracting parties of this idea. Initially, the developing countries, so India, said, oh, no, we already have an organization on trade. Oh, yes, United Nations Conference on Trade and Development. And they serve us much better because they also have development in their title. For the rest, for the developed countries, this was like an over our dead body. Yeah? This will not fly. This is a UN organization, and they're all still in the idea of a new international economic order. No. These are not the people that we can trust. So discussions continued, and they continued to push for this multilateral trade organization. And gradually, they convinced the rest of the world that, yes, okay, all right, this may not be a bad idea to have this new multilateral trade organization. Some of that convincing was not very pretty, because the European Union went around and said, so you're against that proposal. Think twice. This is not smart of you to be against, because you get development assistance from us, you get market access from us. Don't put that at risk. Now, if there was a European Commission official here, they would deny, no, we never did that. I know they did. Yeah. And I know some of the people who are on the receiving end of that sort of threat. This is the way the world works also. Eventually, everybody was on board. And we're now talking November, early December 1993. Everybody agreed on this new multilateral trade organization, except for the United States. I just say, no, another international organization. We have already too many, and then we end up paying most of it. No. And then there was a moment, and this is part of the French, they would say, la petite histoire, huh? So the sort of the things that one tells about these events. There was a congressional delegation that flew into Geneva, U.S. congressional delegation that flew in from Geneva in early December in order to talk to the USTR negotiators, United States. I've heard many of them, but that's a nice one. United States Trade Representatives, delegate, negotiators, they came to talk to them. And in that delegation, there was a very, very forceful, actually, if you look at pictures, I never met the man, but I've seen pictures. I mean, he was the Irish descent, the senator of New York, from Irish descent. Huge man. Tip O'Neill, very forceful person. Politically very Democrat, but politically very, very, very strong, well connected. And he asked the negotiator at a certain point, so what about these negotiations? And the USTR said, well, we've got this, we've got an agreement on services, we've got an agreement on trips, property rights, that we had to push through the throat of the Indians, but got it. We've got better rules, at least they thought they had better rules, or they got better rules on trade remedies, and so on. So Tip O'Neill said so. Why don't you accept this? What's still? Well, there's still this breaking point on having this new organization. No. Let them have their organization. There's too much goodies on the table. We want this agreement to succeed. This is going to be good for America. But then he comes back and he says, but what are you going to call this organization? You've heard my story. What are you going to call this organization? They propose a multilateral trade organization. Oh, no. Multilateral? What on earth is multilateral? This is not something that will win the hearts and minds of the American people. The 6 o'clock anchor will trip over the word. Multilateral? Yeah? No, you have to more forceful. Let's call it World Trade Organization. And that's what it is. Yeah. When the American negotiators flew the same evening from Brussels, Ottawa, and Ottawa was not evening yet, but Mexico City, when they phoned, people fell off their chair there. They said, what do you want to call it? Well, that's fine with us. We didn't propose that because we thought we would never get away with a World Trade Organization. That would definitely be unacceptable to the United States. But if that's what you want to call it, fine. There was only a problem a little bit later. The next morning, they found out that there was already another international organization by that same name, the World Tourism Organization, WTO, a UN organization. Never heard of before, never heard of since. I'm sure that they do very good work, but that was somewhat of an embarrassment never. But it also illustrates how, this happened very, very quickly, and that we now have the World Trade Organization rather than the Multilateral Trade Organization, thanks to the Americans. Yeah. Right. But this was the breakthrough that was succeeded in December 1993. The WTO was then, the agreement was signed in Marrakesh. What did I say about trade diplomats treating themselves very well? They were negotiating in Geneva, seaside, lakeside building, very, very nice. For 9 years, I had an office with a view over the lake. I'm missing that office. But they signed the agreement in Marrakesh, Morocco. So a very nice holiday destination. And it entered into force on the 1st of January, 1995. Right. With regard to the mandate of the WTO, and again, this is important if we want to link it to climate change action. Yeah. First of all, the mandate. Where do you find the mandate? Where do you find the objectives of an organization? I think all lawyers here in the audience will agree with me that you look at the preamble. Yeah. Do not let anybody tell you that a preamble is not really important. Preambles are very important. Preambles are language over which negotiators work. They negotiate over it for days and days and nights. Yeah. It's important, and as the appellate body has said, it gives it gives texture and color to the obligations. You can only understand the obligations correctly in the light of the objectives that you find reflected in the preamble. Now, what do you find in terms of preamble of what do you find in the preamble of the WTO agreement? Higher living standards, and that's an objective, full employment, the growth of income and demand, expansion of production and trade in goods and services. Anybody objecting? I don't think so. Yeah. But these were the objectives that were already reflected in the GATT 1947. Exactly the same language, with the exception of the addition of services. Didn't the negotiators learn anything over all these years? Yes, they did, because it doesn't, the preamble is not finished yet. Preamble continues to say, as an objective, also sustainable development and the protection of the environment are important. And the concept of sustainable development was used. It's one of the very first times that in a multilateral agreement that does not specifically deal with environmental issues, that the concept of sustainable development was used. So, I mean, does the WTO stand for environment? Yes, yeah, it does. At least according to its objectives as reflected in the preamble. And then lastly, also explicitly stated in the preamble, WTO is there to ensure an equitable share in the growth of international trade for developing countries and especially for least developed countries. It's at least the objective of the organization. There are two instruments that are available to achieve these objectives. First of all, agreements on the reduction of trade barriers. And secondly, very importantly, and we'll come back to that when we talk about the cases, very importantly, the elimination of discrimination. When you talk about the mandate of an organization, you look at the objectives, yes, of course, but you also look at the functions that they have been given to exercise these objectives. These functions are First of all, the facilitation of the implementation, administration, and operation of the WTO agreements. And is the very boring sort of day-to-day work in Geneva. Most trade diplomats in Geneva spend most of their time on this, but it's very valuable work. It's very important work. It's follow up what really happens and who has a concern about what. So India, for example, regularly raises trade concerns in the TBT committee, in the SPS committee, in other committees, where it brings to the attention of another WTO member, but also of the whole membership, concerns it has about trade measures that are taken by others. Second function, the negotiations of new rules. And I'll say a bit more about that at the bottom of the screen. Third, and again, I'll say a bit more about that in a moment, the settlement of disputes. Four, trade policy review. Well, my hope is, but disappointed in that hope, my hope is that you will all find a little bit of time this evening and to look at the latest trade policy review on India of the WTO. It's a gold mine of information. If you want to know about what India's trade policy is, then the WTO will give you a full report on what the trade policy stands for. Objective. You can also read, there's a parallel report every time of the government itself, of the country, so you can also read the Indian government's presentation of its trade policy, but you're probably more familiar with that. Yeah? So this is a gold mine of information. I, again and again, whenever I have the opportunity to talk to audience like yourself, like yours, emphasize this. Have a look at the WTO website. It's easy to find back. Then a fifth function is the cooperation with international organizations and NGOs. Speaks for itself. And the WTO is actually doing quite well on this cooperation with both. Yeah, it's never enough. Yeah, but they're doing pretty well. And then finally, this is a bit of an embarrassment because this is a function that is not mentioned in Article 3. It's not mentioned. Yeah. And it's an embarrassment because now it is being marketed as one of the big things that the WTO does. It's technical assistance to developing countries. It's not identified as a special separate function, but it is what they do, especially since the beginning of this millennium, since the failure of the Seattle Ministerial Conference. That's what they do. Has the WTO, and this allows me to come back to some of the functions, has the WTO been a success or a failure? Well, let's take the two most important functions. I think on the other less important functions, I've already said that they've done pretty well. They've done pretty well on trade policy review. They've done pretty well on cooperation. They're certainly improving on technical assistance. And I've highlighted the importance of the first function mentioned in this list. But what about negotiations and dispute settlement, which are often the functions on which most attention goes? Negotiation function, well, what do you think?
Pretty well in the contemporary times, with agreements being negotiated in the plurilateral track.
Okay, well, we'll get there. We'll get there because this is a painful point for me. Negotiations. Well, the biggest effort, biggest attempt of the WTO to update the rules book, to create new rules, is referred to as the Doha Development Round. Doha Development Round, which started in 2001 and which has been clinical debt for many, many years, but hasn't closed yet. And why has it not closed? Because India blocks the decision to close the round. You need a consensus decision to open a round, and you also need a consensus decision to close a round. You close it unsuccessfully, but you need a decision to close it. India says, no. There are still, and we still insist that a number of the Doha development round agenda points, issues, are being discussed and are given priority in discussion over anything else. Only then we will be willing to close the round and move on to other issues. But the Doha development round is clinically dead. Yeah? Some of the issues are being discussed, but not necessarily the one that India would like to see discussion on. So the Doha development round has been a failure. But I say, but ... And the but ... is important. I think the WTO, in terms of its negotiating function, has gotten bad press, too bad a press, because everybody focuses on the Doha development round. But there have been numerous agreements, decisions that have been taken over the last years. And I don't think it's in this presentation, but I have a page slide full of agreements, and then we talk about, for example, the trade facilitation agreement or the agreement on fishery subsidies or the decision on export competition, which abolished the agricultural export subsidies. So decision and agreement after decision. Now, over the span of now almost 30 years, has it been a lot? Oh, no. But still, it's not that the negotiating function was completely without its success. The second function is the dispute settlement function. And here I may get emotional. Yeah, the dispute settlement function has been, for many years, has been correctly referred to as the jewel in the crown, as the thing that practitioners and lawyers and others in other fields of international law envied WTO for, because they had a binding, compulsory, independent, impartial, rules-based dispute settlement system with teeth, could actually enforce enforcement mechanism, which had its defaults, big defaults, but at least there was a system which you normally don't find in international law. Fortunately, in December 2019, the United States was able to pull the plug, and the appeals level of this system is now dysfunctional. It's paralyzed. Why? Well, because they refused to appoint new judges. I have never been replaced. Neither has Ambassador Bhatia, who was one of the last serving appellate board members. When he retired after his 8 years in function, it was also not replaced. So from 7 judges, we went down to 6, 5. It's like there's this Hollywood movie, that in a room you have, initially you have 10 people and then 9, and you get all killed away and then all disappeared. Sorry?
And then they were.
Yeah. So, with only one judge in function, which was happened to be a Chinese judge, in December 2019, the appellate body became dysfunctional. With the appellate body being dysfunctional, not operating anymore, the whole dispute settlement system was in trouble, because what happened is that when there was a ruling at the panel stage, yes, the panel stage still works. Yeah, I'm at the moment, I'm a panelist in 2 cases. 2 of the 14 cases pending at the moment, I'm a panelist in 2. So the panel stage still works. But what happens when you lose at the panel stage? You appeal to the appellate body. And the appellate body can't take the case because they're not functional. And as long as the appellate body has not decided on the appeal, and they will not, they can't, the judgment of the panel cannot become legally binding. So what does a loser do after receiving a negative panel report? They appeal into the void, as it is called. So now some reports are adopted. We'll talk tomorrow about such a report. The EU palm oil report has been adopted. But most of them are appealed into the void. The European Union has created a parallel system, a temporary parallel system called the MPIA, Multi-Party Interim Appeal Arbitration Arrangements. But that only works for appeals among its parties. And India, and every visit to India, I try to argue for this with people that want to listen to me, but India, in its wisdom, has decided not to become an MPIA party. I hope they will change their mind at some point, because India is one of the last big players that is missing in the game. All the others are big traders, with the other exception being Korea, are now MPIA members. And that would allow for full resolution of disputes. So if you have any influence in the circles of government, and you're convinced by my arguments that we really need a rules-based system, then argue for India joining the MPIA. Membership, 166. Yes, please.
I had a question regarding the negotiation function of the WTO.
Excuse me.
I had a question regarding the negotiation function of the WTO in context to climate change and how to deal with it. So I think it's an uncanny area where developed and developing countries agree is that the WTO is not a place for discussing climate change and the environment. That is India's officially stated position.
Yeah.
And I also think some other developed countries have stated that.
No.
And I think that in my opinion, the reason is to avoid any real consequence, more name and shame than to have tariffs and barriers with regard to climate change. But like, do you think that there is a point to this? Is this gradually changing? Do you think the WTO can adapt itself to discuss climate change in negotiation?
The reason why you have to discuss climate change in the WTO, and why also India has to join these discussions, we'll talk about the discussions in a moment, they have to join. The measures that are taken by countries are, as we will classify them, trade-related climate measures. Yeah? So they are climate measures. Yeah? CBAM is a climate measure, at least if you ask a European Commission official, he said, but it affects trade. And when you discuss trade, you discuss trade in the WTO. Where else could you discuss CBAM? Where else? Somewhere in the UN. In the UN Environmental Programme meetings, somewhere in, even in the COPs, under the umbrella of the United Nations Framework Convention on Climate Change. Discuss CBAM. Well, you could start discussions about carbon pricing, yes. That is not to say that these issues have to be discussed solely in the context of the WTO. Not saying that. The more places in which they are discussed, the better. But I think since measures taken to fight the climate change are, all of them, but some of them are trade-related measures, we discuss them in the WTO. Yeah. And to the extent that there is a functioning dispute settlement system, the advantage of discussing them there is that any new agreement or amendment of existing agreements would be subject to rules-based resolution of disputes. Where else do you find that? So membership, You all know that there's both states and autonomous customs territories. So WTO members are not necessarily states. So they can also be autonomous customs territories. This is the flag of one of them, yeah, namely Chinese Taipei. Yeah. The European Union is also a member, together with all its member states. Both the European Union and its member states individually have full member state status. Developing countries make up the largest part of the membership of the WTO. But don't ask me to put an exact number on the number of developing country members, because that is very controversial. Why is it very controversial? Because one is a developing country member on the basis of self-selection. And that self-selection is highly controversial. Is Korea still a developing country? Well, if you ask a Korean diplomat, is duty bound to say yes. Yeah? They're still a developing country. They don't claim any of the privileges that comes with it, but they will out them as a developing country. Singapore. Been in Singapore? That's a pretty rich place. Yeah. Singapore, same thing. So there's a self-selection idea. The WTO does follow the UN classifications for these developed countries, but not for developing countries. That's highly controversial with developed countries, because they say, well, I mean, we recognize the developing country status of many developing countries, but China and the United States goes further. The United States puts India on the list of countries that should not be able to claim developing country status. Now, the European Union didn't go that far. So, membership obligations, yes, obviously all your legislation, all your measures should be WTO consistent. But this is why claiming a developing country status is important, especially in differential treatment. But having said that, most special and differential treatment provisions are not worth the paper they're written on. They are should provisions. A developed country should do this too, or for a developing country. You're all lawyers. Should is not shall. Yeah. So it's like, yeah, or the provisions goes like, the developed country shall consider this or that. As a judge, I've broke my heart in a case involving the European Union, where they are reading, oh yes, we considered, and then we did something else, but we considered. There's nothing you could do about that, because that's what the obligations say. You shall consider. We did, honestly. Waivers, yeah, no. I want to finish this lecture. When I say no, I should say no. Obtaining membership and ending membership is somewhat less important in this audience, because you have been an original member, because you are a GATT contracting party and you stepped into it's a much more problematic thing for those that were not GATT contracting parties, but had to negotiating their membership. And negotiating membership of the WTO is a nightmare. Yeah. Most international organizations, if you want to become a member of that organization, you have to sign on the dotted line of the charter, the treaty, and they will roll out the red carpet and offer a champagne reception. WTO, you negotiate for years and years and years, and they're brutal negotiations. And you're likely to have to accept the WTO plus obligations and rights finance. Ask China. Those that say that China was let into the WTO at soft terms should read the accession protocol of China. China was made to join on very harsh terms, and there are WTO plus obligations on China that are not on any other WTO member. So they have obligations that nobody else has. Now, when I say that nobody else, I'm talking to the original members, because Russia, for example, has similar obligations, for example, with regard to the prohibition on export duties. United States, European Union, India can impose export duties as they wish, because there are no rules under the GATT on export duties, under WTO law. On joining the WTO, China had to agree that they would not import, they would not impose, they would not adopt export duties on, importantly, critical minerals. Other products too, but that's what now bites. On the withdrawal, perhaps the word on the withdrawal, because you will probably hear President Trump threaten again that he will withdraw from the WTO if they don't act up. He won't. Yeah. Because if he would withdraw, now you can't say that he won't, because honestly, it's not all rational what happens there. But if he would, United States would lose most favored nation treatment. And that's, we have never seen a WTO member leave the WTO. And I think we're very unlikely to see.
Why are the restrictions so strict for joining WTO as compared to other organizations?
Sorry, say it again.
Why are the restrictions on joining WTO that strict as compared to other organizations? Is the rational view?
Which correctly, there are international organizations that have an easier or less effective. Well, no, let's put this differently. The Trump administration is going to withdraw from the World Health Organization. Yeah. Procedurally speaking, there's no difference. It's as easy to withdraw from the WTO as from the World Health Organization. Procedurally, there's no difference. But the consequences for the country involved, at least the long and short-term consequences of withdrawing from the WTO are just so much more impactful than. But I'm not sure whether I got your question. But let me. Oops. Okay. This is the map of WTO members and those that are not yet a member that are in the process of negotiation or observers. Institutional structure, pink pyramid, yeah? Obviously with the ministerial conference at the very top, meets every 2 years, a couple of days, big media event, all the all the ministers, and in the beginning of the WTO, also the heads of states. I was fortunate when I was a senior advisor to the appellate body, we had a ministerial in Geneva, where at the time, where there was Clinton was there, Fidel Castro was there, Mandela was there, all giving saying beautiful things about the WTO. So this was the same time they had turned the whole of Geneva into a fortress. Couldn't move anymore. And all of a sudden there was a helicopter landing in the garden of the interesting times. All right, but political bodies, the ministerial conference, the in between meetings of the ministerial conference, in between, there is the General Council, which is composed of ambassadorial level people. Now, that General Council has all the competences of the ministerial conference in between meetings. It meets as the dispute settlement body when it talks about dispute settlement matters. So the dispute settlement body is indeed the General Council, but when they talk about dispute settlement matters, it becomes the dispute settlement body with its own chair and own rules of procedures. The same is for the trade policy review body. At that level, underneath you have the specialized councils, trade in goods, trade in services, and TRIPS, and then under that you have multiple committees, working groups. The Committee on Trade and Development, the Committee on Trade and Environment, one that is important for us, the Committee on Regional Trade Agreements, the TBT Agreement, the TBT Committee, the TBT, ESPS Committee, and so on. Yeah, many of them. Don't ask how many. For every edition of my book, I contact my friends in the Secretariat and I said, here I am again, because I'm now working on the 6th edition. Here I am again. How many committees are there? And said, Peter, well, you know that we can't tell you that. Because if we give you a number, you're going to put in footnote that your data came from us, and then we will be challenged by the members. So how did you count that? Did you count in the committee that I asked so many years ago that has been dysfunctional, but we never decided not to have that committee anymore? Committee or working group. So they do not want to tell you how many there are, but there are many. Some of them are very active, others less so. Now, separate from the political bodies, you have the judicial bodies, and that is, of course, first the ad hoc WTO dispute settlement panels and the standing WTO appellate body, now paralyzed. This is a picture of happier years with Ambassador Bossche. Yeah, and yeah, happier years. 2016, because this is a colleague from Korea who was the first one to become the victim of American action against the appellate body, because he was not reappointed for a second term of 4 years. And why was he not reappointed? USTR actually initially came out with a statement like that. He ruled against us. Yeah. If as an international judge, where you have sworn to be independent and impartial, you get not renominated if you rule against the United States. Now, the fact that whether he did that or not cannot be known, because decisions are taken by the division. And the vote is, and he might well have been in a minority. But no, this was a signal that the United States sent to the appellate body, trying to exercise pressure. I have.
Later on, he negotiated chorus with US also. He was part of the negotiation also.
Him or his successor?
He only, sir.
No. His successor. His successor came in. He had been the trade minister of Korea. His successor, Joan, because one Korean was replaced by another Korean with the blessing of the Americans. We're on camera, right? Should be careful what I say. Joan who had been trade minister, but only stayed with the appellate body for a short period of time because he was renominated trade minister to fix problems they had with the United States, because he had been involved in earlier negotiations with the United States, trade negotiations. Anyway, but Joan is not on this picture. Right, standing appellate body, so WTO Secretariat. I always have people in the audience whose dream and ultimate career plan is to join the WTO Secretariat. Now, I can only encourage this. It's a very interesting place to work, but to be realistic, it's a very, very small secretariat. 650 around, and that's from driver of the DG up to the DG him or herself. Yeah, so it's a small secretariat, very small secretariat for the work that he does. It's partly reflected that much of the trade work is done in national capitals. Well, a word about the Director General. We currently have a formidable Director General. It's a force of nature, which is not always and everywhere appreciated. All right, but I'm an admirer of hers. Dr. Ngozi from Nigeria, who was very recently appointed for a second term. Normally that that a decision should have been taken early 2025. But when it became clear that the next president would be Mr. Trump, they, the whole organization, and the United States included, hurried up and appointed her for her second term earlier than it normally would have been. Yeah. Important again, last point on the Secretariat, and for the limited function of the Secretariat, some of you already asked, and so what can the WTO do? But don't expect too much of the Secretariat. Yeah? Expect something from the members, because the Secretariat is confronted again and again with the saying, and ambassadors will often repeat this, the WTO is a member-driven organization. And you should read that and not use Secretariat. Huh? Use Secretariat are not telling us how to run the ship, how to drive this truck. But it is a truck that is being driven by 166 drivers. They all have their own ideas, and the truck is not going anywhere. Under forceful directors general, as this one, and also Pascal Lamy, of years back, forceful. There, of course, the Secretariat plays a more important role because but remains a member-driven organization. Okay, this is the decision making, and very quickly, standing on this side of the classroom, here I'm talking about decision making in theory. Decision making in theory is that decisions are taken by consensus, and if no consensus can be reached, then there will be voting, majority voting, except for special matters where you have qualified majority requirements. That's in theory. Now, walking to the other side of the classroom, I've done this before, right? Walking to the other side of the classroom, this is, I can hardly get further away from theory, practice. In practice, decisions are taken by consensus, and there is no voting. Now, the lawyers among us, all of us now, get concerned. But there's a possibility of voting. Does not happen. There have been a few decisions in these 30 years, and primarily in the early years, that have been taken by vote. The accession of Ecuador, for example, to the WTO was voted. There's no consensus decision. But the practice is decision making by consensus. Now, just for me to make sure that you understand what consensus making by decision is, if I table, you're already over time, yeah? But if I put on the table a decision, draft decision, I'm the chair of this meeting, better or worse, that we will finish this class by 6:30 and no longer, no later. What did I say, 6:30? No, 5:30. Wake up. You almost agreed to something that was at 5:30. Finish at 5:30 and no later. This is a decision that I put before you. How does decision making by consensus work? How does this work? Are you going to vote on it? There's no voting. The chair will be looking. Does anybody take the floor? Ask for the floor. And you, madam, you ask for the floor. And you're the ambassador of pick a country. Thailand. Nice country. Huh? And we're all looking at her. And she starts talking. And she said, well, I really appreciate this lecture. And I would not mind to sit here until 8 o'clock. And you go on and you have some 5:30, maybe too early, and all the others are listening. They're waiting to her to say that she formally objects to the proposal. She doesn't say that she formally objects, and she finally finished with her talk. Nobody else talks. It's just adopted. That's decision making by consensus. Now, Is that easier than or more difficult than decision making by unanimity? Well, in a way, it is easier, but on the other hand, it also gives each of you a veto right. You could indeed have objected against this by saying, no, 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 I don't want this. And you might want to do that if some very fundamental economic and other interests are at stake. So you've understood what, and yeah, we now have the decision and there's 13 minutes left. What are the problems with, and it goes back to a question, a comment that was already made earlier, but by you, yes. The problems with and participating in, particularly the problems with WTO negotiations and decision making. Apart from that decisions are taken by consensus, and mind, be careful, I'm for decision making by consensus. Because the decisions that come out of that process are decisions with which everybody can live. Yeah? If you take decisions by voting at the international level, you get decisions like you have in the UN system that really go against the fundamental interests of some of the parties. They will not comply. They will not. Yeah? The developing countries, with their numeric majority, could win vote after vote after vote. But would it be worth having that success? Probably not. Yeah? So decision making by consensus for when you talk about substantive rules, obligations and rights, I think that's the right way to go. Yeah? When you talk about procedural decisions, such as the appointment of judges, yeah, that's another thing. Yeah? Or the adoption of the budget, or the adoption of the agenda of a meeting. And on all of this, the United States has been using its veto power. Even the adoption of the agenda of a meeting. I mean, you've all been chairing meetings. Yeah? And the first thing on the agenda is the adoption of the agenda. And you often treat that as, okay, let's move on. That's, of course, the agenda will be adopted. No, not in the WTO, because there's one member, and the United States has played that game repeatedly, that then objects to the agenda. End of meeting. The meeting cannot take place because the agenda has not been adopted. Now, all right. Now, what are the problems in addition to decision making by consensus? Broad engagement. India is now talking. Yeah? They're around the table. They're at a high table. Yeah? The WTO, the GATT, in the early years of the WTO, there was the Quad, and they ruled the game. There was United States, the European Union, there was Canada and Japan. And whenever something was agreed among those four, sometimes even when something was agreed between the European Union and the United States, that was it. All the rest had to follow. Now we have no longer the Quad, we have the G5. What's part of the G5 was still the European Union, the United States, China, Brazil, and India. But they're now sitting at the high table. Nothing is happening in the WTO without India agreeing to it. So broad engagement. It's not only the G5, it's also developing countries, emerging economies that individually have their voice. Other developing countries are getting better in pooling resources and making themselves heard. This is what many of us have always dreamt of. I mean, I'm involved in capacity building for 30 years. We were dreaming of this situation where developing countries really had a voice, were able to make their positions known, and not only in the negative way, not saying no, 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 but to come up with, we are now in that situation, but it makes the negotiations so much more difficult. So much more difficult because there's a wide diversity of interests. In the GATT days, we thought that there were different between the Quad, European Union, United States, Canada, and Japan. Oh, we thought there were big differences. Interests were very different. We did not know what difference in interest was. Now we have difference of interests. Yeah? With countries like India, a developing country, clearly a developing country, China, Brazil, European Union, United States, in terms of economic development, in terms of political system, in terms of economic system, very, very different. Yeah? Difference between the rivalry between market and state capitalism, the novelty and complexity of new issues. Trade diplomats now have to talk not only about global warming, but they also have to talk about artificial intelligence. I can tell you that more than one of my friends is not, what is that? And what are the impact? And so new issues that have to be dealt with somehow because they have an impact on trade. Is there a need for rules? As I said before, this is an audience that's playing a home game here. Yes, of course, there's a need for WTO rules and new WTO rules. Why is there a need for WTO rules? Well, first of all, to restrain countries from adopting self-destructive, trade-restrictive measures. Yeah. And the European Union can decide to protect the Portuguese shoe industry and ban Vietnamese shoes or impose very high customs duties, but that's self-destructive. Self-destructive. And how do the trade rules help? The minister or the trade commissioner or any politician that is being confronted by the shoemakers, they hide behind the shield of international law, behind the shield of WTO law. They say, oh, I feel with you. I feel your pain. You will lose your job. It's terrible that you will lose your job. But I cannot act differently because these rules from Geneva, these WTO rules don't allow me to. They hide behind the shield of international trade, hide behind the shield of WTO law. And that's a good function if in the end it benefits the society as a whole. Third, to ensure security and predictability to traders. Yes, the rules will give us some security and predictability that certain things will not happen. The European Union will not, if it plays within the rules. For that, you have to have rules. They cannot immediately, all of a sudden, increase the import duties on shoes from 5% to 15%. They can't do that. There are rules on this. This point I don't have to elaborate because everybody who has lived through the COVID crisis knows about this. Yeah? In order to allow for the effective protection and promotion of important societal values such as public health, you need trade and you need regulated trade. Then finally, and I wish I had a bit more time to develop this because it's one of my favorite things. This is why I'm in the field of trade law. When I was a young student, I was invited, as our people of my generations were, to sort of choose a leitmotif. That's German for a motto that guides you in your professional but also personal beliefs and activities. And I choose a saying, a statement by a French Catholic priest, Père Lacordaire, who said this, what I'm going to say, said this in one of his sermons in the Notre Dame in the mid-19th century. So it's way before his time. He was a social democrat when the concept hadn't even been invented. And he said, and I'll first show off with my French, he said, entre le fort et le faible, c'est la liberté qui opprime, et c'est le droit, la loi, qui affranchit. Now, what does this mean? Between the strong and the weak, it's freedom that oppresses, and it's the law that sets free. Think about that. I think this is very, very true. also in international economic relations. Basic rules, we're coming to the end. I think I will keep my promise. Basic rules. We've got rules on non-discrimination, and we'll deal with those as the most favored nation treatment obligation. There is the national treatment obligation. We'll deal with both tomorrow and the day after tomorrow. We have rules on market access. These are the rules on customs duties and other charges on imports and exports. And quantitative restrictions, which are part of the non-tariff barrier, the rules on non-tariff barriers to trade. The quantitative restrictions are just one of them. It's a very, very large category of non-tariff barriers. They include also SPS measures, TBT measures, and so on. And we'll talk big time about TBT tomorrow. Will be an important topic. Rules on unfair trade. I'm currently on 2 unfair trade cases, 2 cases dealing with countervailing duties. These are important, rules on dumping, rules on subsidized trade. And then we have the rules on the conflict between trade and other societal values and interests. And there we talk about the exceptions. We have the general exceptions, we have the security exceptions, we have the economic emergency exceptions, safeguards. We have the economic development exceptions, and I'm missing one, the regional trade exceptions, which allow you to have customs unions or free trade areas. Part of the basic rules are obviously also the institutional and procedural rules for dispute settlement and decision making. Where do we find them? Audience of lawyers to be, which is also a home game. But for other audiences, this is sometimes, we find them in the very first place, and primarily we find them in the WTO agreement. The agreement establishing the WTO, the Marrakesh agreement establishing the WTO. Now, I have a copy with me, brought it to India, but I left it in my room. Look at that book. The Marrakesh agreement is actually only 16 articles long. And all these provisions are of a procedural nature. They set up an institution. So my American friends then ask, so where's the beef? Where's what really matters? Well, the beef is in the annexes. There's Annex 1A, which has all the agreements, the multilateral agreements on trade in goods, starting with, of course, with the GATT, the basic agreement, but also 12 other multilateral agreements on trade in goods. We have the agreement, the general agreement on trade in services, Annex 1B, and the TRIPS agreement, the agreement on trade-related aspects of intellectual property protection, which is an agreement which is not very much liked here in India. We have Annex 2, which is the dispute settlement understanding, Annex 3, the trade policy review mechanism, and 4, the plurilateral agreements. I wanted to say more, but I'll say this later in the course about plurilateral agreements. There, India breaks my heart. No, you're barking up the wrong tree. And now you're wondering, what are we talking about? Stay with me, I'll explain. Now, we're going to finish. So other sources of WTO law, yes, obviously the case law. I would not be able to write a 1,100-page textbook if there was not a lot more to say than what's in the agreements. So there's a lot of case law which is to be considered. There are also some decisions by WTO bodies, especially by the Ministerial Conference, and there's other international law that may be relevant. This is the last chart, but we're already 1 minute over the time that I stole from you. Just as an introduction, and have a look at this in your own time. can talk a long time on this. But this very clearly sets out what kind of trade-related climate measures you can have. And we have. We see in all of these boxes, you have examples, and I could put examples. On the one hand, we have in this column, we have types of measures. You have border measures, obviously. What are we then talking about? We're talking about license tariffs, to start with, import licenses, quantitative restrictions. One could also add here export restrictions. Other type of measures are regulatory measures. Regulatory measures such as standards, technical regulations, labeling schemes, and tomorrow we'll have at least one case which is big on technical regulations / standards. And we have economic incentives as a third type of measures that you can take. Economic incentives, yes, internal taxes, subsidies, yes, subsidies, I mean, tax reductions are, of course, a form of subsidies, non-monetary support, and so on. And it also mentions here intellectual property rights, yes. Right, this type of measures can be used in two ways, and that's how you get 6 boxes. It can be used to discourage the production and the trade in products that contribute to climate change, or it can be used to encourage production and trade in products that help with the fight to. So, go to your question again. What's the relevance of WTO law in all this? Why should we at all discuss this in the WTO context, the climate crisis? It's because we get these measures, yeah? And these measures create conflict where you need rules. This morning I finished the lecture a little bit early, and I told you that I have the reputation to go over time. I lived up to my reputation, for which I apologize. Thank you.